Harry Heist has been the property manager's go-to attorney since 1989. He represents over 11,000 property managers in Florida, and he has filed close to 200,000 evictions. Originally, he's from New Jersey. He went to Seton Hall University, then Rutgers Law, and escaped from New Jersey right out of law school. He has written and co-written most of the pro-landlord changes in the Landlord Tenant Act in the past 30 years. He works for single-family home managers of all shapes and sizes, large multifamily homes and smaller self-managers. His firm has a staff of 22 administrative assistants and 3 lawyers. You should know evict.com is the largest source of Florida-specific legal information for the property manager. EvictTV.com has over 200 free training videos. And evictforms.com has a ton of free forms and notices. And I think I read something saying that you're all going to get an email to access those free forms at the end of the webinar. So Heist, Weiss and Wolk is the largest property management law firm in Florida, and Harry has taught the 6-hour class for property managers here at SCAR many times. So Harry is totally committed to keeping Florida a landlord-friendly state, and those of us who know him and use him appreciate that. And Harry, at this time, I am going to just hand it off to you.
And that was from Kate and from the Pinellas Realtor Association were the only 2 that I accepted. So Kate is responsible for this class. I haven't been able to do your 6-hour class in a while, so I just couldn't say no to Kate. I want to thank everyone that's involved in the property management committee. Most associations of realtors do not have a property management committee, and if they do have one, there's nothing to it, and no one's really serious about it. So the fact that you do have a property management committee is a very, very admirable thing. It's very important. If you do property management, this is going to hopefully apply to you today, and you're going to get something out of it. Hopefully in the time that you've had in this big mess, you've been able to look at your business, look at some of the new things that are going on out there, make changes to your business. I hope you've been trying to make the best of a bad situation. I know that we have. It's just was kind of a time to step back and look at everything, and I think we learned some things throughout all this. But in any event, things are not as terrible as we thought they were going to be. That's the good news. So we'll start out with some good news. As far as delinquencies are not as bad as a lot of people expected. April's was not as bad as a lot of people expected. May is not either. And considering that the unemployment situation in Florida is such a mess, you would think that it would be a lot worse. But there are some of you who are dealing with people who are in the position where they're not paying the rent, and you are in a potential dangerous situation because of the laws that we have right now, the laws that just got put into place. Before I go on, I want to tell you about something that's a really smart thing to do to put in your management agreement. That is a mandatory minimum management fee. Now, I could tell you to do that. I could recommend that you do that. You could never discuss that amongst yourselves. You can't discuss that you're going to put something like that in your management agreement. I'm just throwing it out to you that a lot of property managers in Florida, a lot of them that are kind of in the know, have a mandatory minimum management fee in their property management agreement. The minute they take over managing a property, the owner has to begin paying them. It's not, of course, the same amount as it would be if you have a tenant in there, but whether there's a tenant or not, whether you're collecting rent or not, smart property managers have a mandatory minimum management fee in their property management agreement. I give out a free management agreement. You can do anything you want with. I don't prepare them. I just give it out. I also give it, if you want to just see the wording to see whether your property management agreement has it in there, I would bet that at least 50% of you don't have it in there. And you probably wish you did. And after this, you're going to realize that you probably should have had it in there. All right, we got a lot of confusion going on. There's so much confusion, and you're getting hit with stuff from all different directions. You're getting emails from FAR, you're reading things on Facebook, you're in different property management groups, and it's just an absolute mess what we're dealing with today. The confusion is the biggest mess, but what's really scary is the amount of people that don't even know what's going on right now at all. That's real scary. During the day, I would estimate that I get about 200 emails a day. And the other two lawyers, they get probably about 100 a day. But I get info@evict.com and harry@evict.com. They all come to me. And the majority of people that contact me, they will ask me about an eviction. They'll ask me about a notice. They'll ask me about a non-renewal. They'll ask me whatever question they're going to ask me. And in every single case, I have to ask them a question. I have to say, are you covered? Is the property covered or not covered? And so I ask that question in my email, and then I immediately send them an email that explains what the heck I'm asking about. The majority of property managers do not know what covered or not covered means. And that's going to be one of the most important things that you have to know right now. It's outrageously important, but the majority out there do not know. They're completely detached from the law and what's going on out there. So today you're going to learn that, and it's really important for you to learn it. First things first, educating your owner. Hopefully every one of you has reached out to your owners in whatever way that you normally communicate, and let your owners know that things are okay, that you're in control. You've got things under control. You've got you know what you're doing. Most of your tenants are in fact paying the rent, and there's a lot of fear. A lot of these owners, you know how it is. You got people that are out of state, and they panic when they read things or hear things, and it's totally understandable. And this is a great time to get back to basics and actually talk to people, or send them a personal email and let them know that you are here for them and that they don't need to panic. Because a lot of people do panic, just like when we have a hurricane. When there's a hurricane or a big tropical storm, your owners panic, don't they? They call you up. They want to know, how's my house? Is there any damage to my house? Well, this to me is kind of like dealing with a hurricane or a tropical storm, but just so far worse, and so much, it's just going on forever and ever. After the class, you can go to the website, watch the videos, read all the stuff we have. We have all kinds of articles on the stuff that I'm talking about today. There's so much more information. So if you don't catch it all today, don't feel bad. There's more to it. And then they're also recording this, so you could probably listen to it again. But if you want to dig deeper, go to evict.com. It's all free. Everything is free. There's no catch or anything like that. Dive in and just look at everything that's in there. We put a ton of stuff in there. All right, what are we dealing with right now? We're dealing with something that's so important, because if you make a mistake and you get caught, you can get in big trouble. Legal aid is watching you right now. Private attorneys are out there watching you right now. They're representing tenants. They're diving in. Many attorneys are diving into representing tenants right now. And you're going to say to yourself, well, why would they represent a tenant? If a tenant can't pay the rent, why can they afford a lawyer? Does anybody know why tenants can go to a lawyer? They go to a lawyer because the lawyer's free. Just like personal injury lawyers. If you're a tenant, you can go to a tenant lawyer, and that lawyer will take you for free. And what that lawyer will do is that lawyer will look at your eviction, look at the notice, they will look at things, and if they find something wrong with it, they will represent that tenant for free. And if they represent that tenant for free, they will go after you for attorney's fees, meaning they'll bounce the case out of court, they'll get a judgment of attorney's fees against the owner of the property, and here you could have filed that eviction, and now because you lost that eviction, you could end up having to pay, your owner could end up having to pay anything between $2,000 and $35,000, $37,000 in attorney's fees. I've actually seen this, and I see it on the low end, like $2,000, $5,000. I see it all the time. It's serious stuff. It's become a cottage industry. Lawyers are out there representing tenants. So don't ever feel that you're safe because your tenant is broke. You're not. The more broke your tenant is, the higher chance that you actually have of dealing with an attorney. Got to keep your eye on everything that you do right now, because this is no time to be sloppy in anything. We get away with murder. We file evictions all the time where the 3-day notice is not quite right. There's some amounts on there that probably could be challenged. Something could be a little bit wrong with it. Maybe the lease wasn't signed by everybody. We get away with stuff all the time. But when we're being watched, that's a different story. So you are being watched right now. It's time to do things right. And I like people to do things right all the time, not just now. But this is a time where you really have to say, I got to shape up. I got to dot my I's, cross my T's, because it's serious. What are the 3 things we got going on right now? First thing, The Supreme Court of Florida, and this is easy. You can write these dates down. It's just a few dates you're going to have to write down. It's very easy. The Supreme Court of Florida said no writs of possession. The writ of possession is the end of the eviction. No writs of possession until after May 29th. So no matter what, I don't care what eviction it doesn't matter what happens. You could have filed an eviction before this all went down or whatever's going on. There's no writs of possession until after May 29th. The sheriff will not kick anyone out until after May 29th. And that's because of the Supreme Court. That's what they had to say about it. The next thing you need to worry about is the executive order by the governor. And most of you, I hope, have been following this. Most of you thought that today was going to be your day that you could serve 3-day notices because the executive order was expiring yesterday. But what did the governor do? The governor extended it. The governor extended the ban on non-payment of rent evictions until June 2nd. You got that? That's another date to write down. June 2nd is going to be your lucky day for a lot of you. Not all of you, and we're going to get to that. But for a lot of you, June 2nd is going to be your day. Your day was going to be today, but now it's going to be actually June 3rd. June 2nd is the day that it expires, so June 3rd is going to be a big day for any of you who have people who haven't paid the rent. Now, some of these laws are written up fairly vaguely. And so I just mentioned two things. It's a bit vague, but it's clear enough. Here's the deal. A lot of people think that these laws, and I told you about two of them so far, but they think these laws only apply to people who are affected by the COVID-19 situation, people who lost their jobs. So if a tenant can prove that they lost their job, then they won't be evicted. That's not true. It applies to everybody. I don't care if your tenant's got $1 million and just decides that he doesn't want to pay his rent, the laws are going to apply. They don't have to prove any need. They don't have to prove any harm. They don't have to prove anything that happened because of the COVID-19. They don't have to prove they lost their job, nothing. Okay, so I hope you're getting that. There's no relation to the tenant situation and the law. It applies to everybody, every single person. You make a little tiny mistake, I told you, you could get hit with a lawyer who's going to grab the case for the tenant. Even the attorney general in some other states have gone after property managers who served 3-day notices. There's some property managers who served evictions, who filed evictions. Check this out. You're going to be surprised. Some of you might know this. Did you know that you could go down to the courthouse right now? You could prepare the paperwork for an eviction. And most courthouses in Florida, if you give them the money, you hand them the paperwork, they will file the eviction. They will. It's totally in violation of the executive order of the governor. But the clerk's office is not the police. They take papers, they take money, and they file them. That's what the clerk of court does. It's illegal. And you may have heard of people, somebody that you know might have said, oh, I filed an eviction the other day. Well, good for you. Guess what? You just violated the governor's executive order. I have not filed any non-payment of rent evictions, and we usually file 50 to 100 evictions a day. I haven't filed one eviction at all since April 2nd, not one. Now, what does it apply to? It applies to evictions for non-payment of rent. Now, you could potentially file an eviction for other things, and we're going to get into that for a second, but it's pretty simple right now. Your hands are tied until after June 2nd. So June 3rd will be your day. Your hands are tied. Now, can you serve any type of a notice to your tenant right now? And this applies to all properties, okay, all residential properties. Yes, you can. You can't serve a 3-day notice though. Why? Because a 3-day notice threatens something. It says, if you don't pay, we're going to evict you. We're going to terminate your tenancy. You can't do that right now because you have no legal right to terminate their tenancy. You could send all your tenants right now what's called a reminder letter. If they haven't paid the rent, there's a letter that you could send, and it's on my website. What I'm going to do is I'm going to give you a Dropbox file. Maybe I'll send it to the association, then they can get it out to everybody else because I really don't know who's here, their email address. So I'm going to send this out, and it's a Dropbox file with all the forms, all the notices, and everything I'm referring to you to about today. It's all in there. A reminder notice is basically a statement telling the tenant what they owe. You're allowed to do that. No late fees, no late fees, no late fees. Late fees are gonna kill you. If you put late fees on anything right now, it's gonna be deadly. On June 3rd, when you serve your notices, for most of you are gonna be able to serve your notices, if you put late fees on that notice, good luck going to court. If the judge sees it or if an attorney sees it, you're gonna have big problems. I know you like your late fees. Everybody likes their late fees. Most property managers keep the late fees according to their property management agreement, and I recommend that. But right now, you got to just cool down on the late fees because you don't need anything like that to mess you up. Now, whether or not you're going to be allowed to serve a 3-day notice on June 3rd is going to depend upon the type of property that you manage. That we're going to get to. That's the real tricky thing for today. But the main thing is right now, just hold off on any 3-day notices. You're going to use the reminder notice for any of your tenants that have not paid rent right now. If they have a non-compliance, for instance, drugs, maybe if the lawn is 3 feet tall, the association management company is coming down on the owner because your tenant's doing something outrageous, unauthorized occupants, unauthorized pets, you can give notices for that, just like before, the 7-day notice to cure, right? That's what we use, 7-day notice to cure. And if you had to file an eviction right now on a 7-day notice to cure, you can file an eviction right now. The ban, the hold, the suspension of evictions only is for non-payment of rent. Non-payment of rent. So you can non-renew people right now. You can serve a non-renewal notice. You can serve a 7-day notice, and you can evict a tenant right now for those things. But listen carefully. For those of you who already knew that, you were all of a sudden you knew that you couldn't evict them for non-payment of rent. So what did you start to do? I know exactly what you did. You started looking around for something else. You're thinking, well, maybe I'll evict them for the unauthorized occupant. I'll evict them for the unauthorized pet. I'll evict them because I got that letter from the association, the attorney for the association that's threatening my owner. I'm going to evict them for something else. So you thought you can get around it because the law only applies to non-payment of rent evictions. Listen here. The judges can see right through that. You go to court with a weak case like that, and it turns out the real reason is that your tenant hasn't paid the rent in 2 months, and now you're trying to evict them because they have an unauthorized occupant or they have an unauthorized pet. You see what's going on here? You can't go through the back door like that and use those other means. It's got to be something serious. If you want to evict somebody right now, you can. And you could serve them a 7-day notice, and you could serve them a notice of non-renewal, but it better be for something legitimate. I'll give you an example of something very legitimate. Owner wants to sell the lease is coming up to the end. The owner wants to sell their property. Is it legitimate to give them a notice of non-renewal? Absolutely. That's totally legit. But if your real underlying reason to evict the person is because they haven't paid the rent, then you can't. You're going to be under the ban, the suspension, the hold on evictions that's going to last until June 2nd, and June 3rd is going to be your date. The executive order prohibits non-payment of rent evictions until that date. So look at what you're doing. Don't get excited about trying to evict people for other stuff. If you're really trying to evict them for non-payment of rent, just forget it. You got to hold off. A lot of people complained about that. They're like, oh, I can't believe the governor did that. He extended the eviction ban and did all this. Well, let me tell you something. You take a look at some other states. If you think the law is unfair in Florida, you are totally 100% wrong. Because of the efforts of the Florida Association of Realtors, the National Association of Residential Property Managers, because of the power of those two organizations, combined with the massive power of the Florida Apartment Association, Florida is a landlord-friendly state. So don't complain about anything that just happened right now on the state level, because this was no big deal. Okay, yeah, it was a 60-day, basically a little bit more than about a 60-day hold on evictions. It could have been a lot worse than that. In some states, they got 6-month holds. Some states, almost a year. It's crazy. We live in a very great state, and it's because we got great property managers, great associations, we've got people who care enough to make sure that our legislators don't go off the rails. Because if you don't sit at that table, the legislators will go off the rail. What was that table recently? When the governor was deciding whether to extend the eviction moratorium, guess who was at that table? DBPR, FAR, NARPM, and FAA, along with Legal Aid. Legal Aid was there. They were there and they were fighting. They wanted to extend the moratorium on evictions all the way until the end of July. That would have been really bad. We don't want that. So that's the scoop with that. We do not complain at all. I know it's a little inconvenient and some of you are angry, but it's really a really good situation. Read the articles on non-renewals and non-compliance so you understand that your hands are not completely tied, but as far as non-payment of rent goes, you're just not going to be able to do anything. And like I said, it doesn't apply to people who lost their job or had any COVID effect or anything. It applies to everything and everybody. Now, it doesn't apply to commercial. So if you guys are doing any commercial, that's a different story. So now, let's say June 2nd comes along. So here you are, June 2nd, you're in the clear. June 3rd, you're going to go out there and serve your 3-day notice. I told you that you can. And unless the governor extends it again, which I hope he doesn't, if he doesn't extend again, you're going to be okay. But will you? This is really interesting stuff. This is when the CARES Act kicks in. The CARES Act is in place right now, but because we couldn't file evictions anyway, we didn't really get too concerned about it. But the CARES Act covers what's called covered properties. Now you're saying covered properties. What's that? Covered properties. CARES Act? Oh, you mean like HUD or Section 8, low-income housing tax credit, something like that. Yeah, you're right. CARES covers those types of properties, but it also applies to a lot of the properties that you're managing right now. And this is big stuff. This is not good news at all. CARES, the act that was signed on March 27th, CARES covers any properties where the financing is connected to the federal government in some sort of way. What are some of those things? Fannie Mae, Freddie Mac. Do you know how many properties you manage are probably connected to Fannie Mae and Freddie Mac? If your property is connected to Fannie Mae or Freddie Mac, you will not be able to, you are covered under the CARES Act. You won't be able to do anything for a really long time. So you need to learn that word right now, covered. Covered means covered under CARES. If a property is covered under CARES, you must abide by the CARES Act. If it's not covered under CARES, you can file away. On June 3rd, you could serve your notices and do everything that you normally do. So here's your first big task. Find out if the property that you manage is covered or not. How do you do this? It's not easy. First of all, you got to speak with your owner. If you speak with your owner and your owner says that they own the property outright, they don't have a mortgage, then you are not covered. So that's good. Not covered is good. Covered is bad. Sometimes we think covered sounds like a good word, like you're covered in insurance or I'm covered. No, covered is bad. So if the property is paid off, then you're not covered under CARES. So that means June 3rd, everything is going to be good for you. Now, if an owner tells you that their property's paid off and you want to confirm that, you can do a quick $50 title search. Now, most title searches cost more than $50, but there's companies out there that for $50, or you might have a friend that works at a title company, which a lot of you do, have friends that are in that business, you could just confirm. I just need to confirm that the property, there is no mortgage on the property. There's a really good chance that the property you're managing does not have a mortgage. That's great. So your first task right now, your very first task right now is to, well, your first task is to relax because your hands are tied until, what did I say? June 2nd, June 3rd. But your first real task is to find out about your properties. And don't delay. There's people today, this was going to be your day that you could have served 3-day notices, but a lot of you didn't even find out. You still don't even know today whether the property that you manage is covered under CARES or not. So your first task will be to take all your properties, and this is going to be a lot of work. You're going to notify all your owners, and I have a form for this. Ask your owners. Now, you don't have to do this for everybody, but I recommend that if somebody hasn't paid the rent, then you better do it because you can't file an eviction until you find out. A lot of the courts are going to require you to file an affidavit when we file an eviction, or even if you file an eviction on your own. A lot of the courts in Florida, they just started, but they're all going to do it. They're going to require you to file an affidavit stating that you researched the property and you made sure it was not covered under the CARES Act. So here we go. You got all your properties. You find out from your owners, okay, these properties, these are paid off properties. So you put them over here, you designate them in their computer. These are the properties I don't have to worry about. Then you're going to find the properties where an owner has a mortgage. So maybe 50%, I don't know. In Florida, it's very high percentage. A lot of these investors have paid off properties, and that's great. They're not covered. They also might have a mortgage with a private company. Maybe it's not connected to the federal government. It could be with a wealthy person, a private mortgage. That wouldn't be covered either. But if they have a mortgage with a bank or a mortgage company, you're going to have to take another step. You're going to have the owner check with the mortgage company and find out if that mortgage is connected to Fannie Mae or Freddie Mac. A lot of mortgages are. You don't realize it. You go there, you get a mortgage, you're not thinking about the stuff, you sign the paperwork, and then all of a sudden your bank then starts dealing with Fannie Mae and Freddie Mac, your loans get sold, they get moved around. You have no idea what happens after you get a loan. Anything can happen. So there's a really high probability that your owner if your owner has a mortgage, that mortgage may be covered under the CARES Act. Remember, not all of them. So you're going to research this. Why is it so important? Because if it's covered under the CARES Act, everything is going to get turned upside down. And this is really bad news. If you find out that your owner's property is covered under the CARES Act, June 3rd is not going to be a happy day for you. You will be able to do nothing. If a property is covered under the CARES Act, you cannot serve any 3-day notices at all. You cannot serve any notices at all for non-payment of rent. Until when? Until July 26th. And guess what? It can't be a 3-day notice. You have to serve a 30-day notice of non-payment of rent, according to the CARES Act. That means, think about this, when will you be able to file an eviction? The earliest you could file an eviction on a CARES covered property will be August 26th. That's pretty bad stuff. That is bad. So if you have a CARES covered property, your hands are tied until July 26th. On July 27th, you can go ahead and serve a notice, but it can't be a 3-day notice. It has to be a 30-day notice, which gives them until August 25th to pay the rent. And if they don't pay the rent, then you could file an eviction after August 25th. That's a mess. That's a real mess. Now, what about this? Suppose you find out your property's covered. Over here, I'm always putting covered over here. So covered's over here, non-covered's over here. So we're talking covered now. You find out the property is covered under CARES. Your tenant is not maintaining the property. They're parking all over the front lawn. The police are out there. The condo association is all over you because of your tenants doing something or not doing something. And you figure, okay, well, I could still evict them for something else. I could give them a 7-day notice, right? Because Harry said this stuff only applies to non-payment of rent. Well, I kind of fibbed a little bit. It does just apply to non-payment of rent, but if the property is under CARES, you can't give a 7-day notice to cure. You can't give a 7-day notice to terminate. You have to give a 30-day notice. So do you see what magically happened to the CARES properties? If you're covered under CARES, your notices just transformed from 7 days into 30 days. 3-day notices can't even be served. A person sitting in a property that's covered under the CARES Act doesn't have to pay you a dime. They owe it, but they don't have to pay you a dime until you serve notice, which would be July 27th. And then if you file an eviction, the earliest you could do that would be after August 25th. Would you believe that 50% of all apartment communities are covered? It's bad. And you might say, well, we'll just file the eviction. The tenant won't know. The tenant doesn't know. Think about it. Does the tenant know? Probably not. But if the judges are going to look at this, a lot of judges are not going to sign these evictions because they're going to want to know, is this property covered or not? And then they're going to see the affidavits that are going to come in. And it may be, the judge may require, the courts in different places may require that an affidavit, like I said, an affidavit of non-coverage, an affidavit stating my property is not covered under the CARES Act. So you got to get to work right now if you haven't done it already. Some of you have. Some of you went and you checked with your owners and you asked them if the property was paid off. That's the easiest thing to do. Find out if it's paid off. If it's paid off, great. You don't have to worry about the CARES Act. So all you have to worry about is the hold on the eviction that ends June 2nd. And the other thing you have to worry about is May 29th, which the Supreme Court says you can't do an eviction. You can't execute a writ of possession until after May 29th. Now, if you're confused right now, some people are at this point, they get a little bit confused. They're like, wait a minute, Harry, you're throwing a lot of dates and numbers and stuff at me. It's really not that hard. If it's not covered, June 3rd, you could go ahead and act like normal. Do everything like normal. Don't put late charges on that 3-day notice. Don't do it. But otherwise, everything else on June 3rd, everything's going to be normal. If it's a covered property, everything is going to stay abnormal. And you can see how bad it is. So watch the videos we have on this, read the articles we have on it. If you're not getting it, if you don't understand what covered means, then you got to learn and you've got to find out because when the time comes to file that eviction, if you don't know, then you're going to be delayed. And haven't you been delayed already? Do you want to be delayed any further? What about reporting things to credit bureaus? Some of you guys use software that reports things to the credit bureaus. Can you report anything to the credit bureau right now? Nothing. You can't report anything to the credit bureau. A tenant skips out, owes you a bunch of money. A lot of you will just report it to credit, or some of your software is reporting it to credit. You can't do it. What about repairs? Let's shift gears a little bit. Repairs. Suppose a tenant wants a repair done. And let's say that it's an essential repair, something serious, a leak. There's a water leak in a house. That's essential, right? Oh, let me just mention something. This just came up yesterday. I was reading something on a Facebook page called the Property Management Mastermind Group. And I've read this thing. This guy posts he posts this question. He said, my tenant just called me and says there's a leak in the house. He goes, I don't know where the shutoff is. His question was, can I tell the tenant to go out to the street and shut it off at the meter? And of course, everybody answered correctly, which is yes, you can. But you know how I answered? I said, you really need to know where the shutoff is. Just a little side note. How many of you know where the shutoff is on every one of the properties that you manage? I bet a lot of you don't. So the day's going to come when there's a leak and there's water shooting out all over the place, and your tenant's going to call you freaking out, and you're not going to know where the shutoff is. So put that on your little list about learning your property. I talk about learning your property, learn your owners, know your properties. Well, there's one right there. So from this point on, I hope you're going to find out where your shutoffs are. Maybe put it on a sheet of paper, stick it on the garage, inside the garage door, but make sure it's in your software so the next time something like this happens, you know what to do. But here we go. We've got an essential repair. The tenant calls you up and says, this, that, or the other's going on. I've got an essential repair. Then they won't let you in. There are tenants who play that game. They will ask for something, it'll be serious, and they won't let you in. If they do something like that, what you're going to do is you're going to call the police, call law enforcement, go over there to the property, and then law enforcement will be able to get you in. So if it's essential and they refuse to allow the repair because of the COVID situation, and we got a lot of tenants that are like that. They don't want anybody coming to their house. They don't want any notices put on the door. And hey, you could understand it, but when it's essential, we got to get stuff done. Some property managers, they ask me this question. They say, Harry, if they're not paying the rent, can we refuse a repair? No. You can't do it. Some people say, well, he hasn't paid his rent in 2 months. Why should we repair something? Can't do it. I don't care if the person hasn't paid rent in 5 months. If a repair comes in and it's essential, you need to make that repair. Period. End of story. Now, what about non-essential repairs? That's more common. Non-essential repairs. The tenant's calling you saying that a burner on the stove isn't working, or maybe the washer's not working, the dryer's not working, the ice maker's not working. Is that stuff essential? No. Can people live without those things? Absolutely. But you might send over your person, your handy person, or your vendor. You send your vendor over, and the vendor goes there, and the tenant says, "No, you can't come in." We have this happen a lot. Tenants deny access. They denied access before the COVID-19 thing, but now they're denying access more than ever before. If they deny you access, document everything carefully. Now, documenting doesn't mean just writing it down on your notes. Documenting means building a paper trail, meaning you're going to send the tenant a communication, whether it's by text, whether it's by email, whatever way you communicate with your tenant, maybe regular mail. You're going to say, dear Mr. Tenant, on such and such date, you requested that we repair or replace X, Y, or Z, and you refused us access, or you refused my vendor access. We will wait until you tell us when we have access. So what you're doing is throwing it off on the tenant to tell you when they're going to let you have access. If it's not essential, you don't need to do it right away. There's no reason to try to force access. But here's the game that tenants will play. You might not make a repair, and it's not really essential. But 2 months later, when you file an eviction, because the tenant hasn't paid rent, the tenant will try to say that you're a terrible landlord, you're a terrible property manager because you aren't making repairs. And you're going to say, whoa, wait a minute. We tried to make a repair. You refused access. And then they look at the judge and they say, that's absolutely not true. We didn't refuse access. We've been living here now for 2 months, not getting these things fixed. And the property manager's terrible. We shouldn't have to pay our rent. And you're standing there and say, Judge, we tried, but they wouldn't let us in. They told us we couldn't come in. Well, where's your proof? Where's your proof? The tenant then says, Judge, we never did that. I have seen tenants in court that can lie better than you can tell the truth. I've listened to stories. I'm there, I'm standing there like everybody else. And the judge is sitting up there. I'm standing there. The tenant tells a story. Then the property manager tells their side of the story. And I'm sitting there and I'm thinking, I wonder if my client's lying to me. Maybe that tenant is telling the truth, because some people can lie so good. So just protect yourself. When somebody says that they need a repair done, if they refuse you access, which they're doing right now, if they refuse you access, what you're going to do is send them a communication. We have that letter, we have that sample letter where it says, we tried, you refused us access, you need to let us know when we have access. So it's just a little game that people play, and you don't want to get caught up in that game. I call it I wrote an article and I did a video on it. I call it the denial of access game. It's a game. They play a game, and sometimes you could lose that game unless you know how to play along with it. Now, what about showings? This is a big one right now. Some of your owners are selling their properties. Properties are still moving. Properties are still selling. Tenants are still coming in and still coming out. A lot of you know, some of you use our lease preparation service. We are preparing hundreds of leases every single day. That didn't slow down one bit. There's a lot of leasing activity out there, and there's a lot of sales activity out there. But what about when the sales agent or when you tell the tenant that you're going to show the property? What is the tenant doing these days? It's bad enough when we didn't have the COVID-19 problem, but what are they doing now? Oh, you can't come in. Oh, no, I'm not going to allow the showing of this property. So now the owner finds out. So the owner has a fit. The listing agent or the realtor you're working with has a fit. Everybody's angry. The tenant won't let people in. What are you going to do? What do you think a judge would do? Do you think a judge would evict a tenant? Do you think that would be grounds for eviction right now if a tenant refused access? I don't think so. So you need to explain this to your owners. You need to say, Mr. Owner, we got a big problem right now. We can't even file evictions. That's number one. Number two, tenants are not allowing people into their home. So the fact that your house is for sale, you're just going to have to live with this for a little while. You're going to be stuck with this because a judge is going to be sympathetic to the tenant. I know people who are very, very paranoid about this situation. They don't want anybody coming to their house. They wear masks all the time. They're very cautious. They're very careful. Like my mother, for instance, she's not very young, and she is staying away from everybody. She's all holed up. She's up in New Jersey where it's really much worse, and she's taking this seriously. Whereas me, I don't really take it that seriously. What is your tenant? How about you? How do you feel about it? So, everybody's got a different view about this, but a judge is not going to be sympathetic towards you. They're going to be sympathetic towards a tenant that is refusing access. All right, now, so don't think that you could just go ahead and barge in and you could then evict the person because they're not letting you show the property. Anybody who has a house for sale right now, showing their property right now, is going to be in for a real pain in the neck. There's nothing I can do about it. There's nothing. Now, what about this? Tenant hasn't paid the rent. The first thing you guys need to do is communicate. I talked earlier about communicating with your owners. Communicate with your owners. Tell them what's going on. Tell them that things are okay. Now, what about your tenant who doesn't pay rent? Do you sit back and do nothing? Do you sit back and just, well, tenant didn't pay the rent in April. Tenant didn't pay the rent in May. Our hands are tied. Nothing we could do. Harry says we can't do anything until June 3rd. And if it's a covered property, I can't do anything until July 20-something. Do you sit back and do nothing? Absolutely not. You're going to contact the tenant, whatever way that you do your contact. And I hope that you guys are getting a little bit more advanced. I know many property managers, they use texting. Now, when I say texting, I don't mean texting on the phone. They're texting through their computers. They text to the tenant's phone. And when the tenant sends a text back, it goes to the computer. There's also an app they have on their phone too, but property managers who really know what they're doing, they're texting back and forth to their tenants all the time. And so they have a great paper trail. You've got this great paper trail on your computer. Use one of those programs. If you're not using one of those programs, you're selling yourself short. If that's the way people are communicating these days, then you're going to do that. Now, would you want to give them your phone number for your cell phone? I wouldn't. You could use these text programs, operate right through any number you give them for your office. You could actually use your main company number, and when a text comes in, it bypasses everything and goes into your computer. You don't even see it. It's amazing, and it pops up on your computer screen. There's a company called Property Text Box. A lot of apartment communities use them. Some of you are using software right now. I think AppFolio probably has it. It's built right in. So now communicate. So your tenant's not paying the rent. You're not going to sit back, out of sight, out of mind. No. Mr. Tenant, what's going on? And then they tell you their sad story, right? Everybody's got a story, always. They tell you they lost their job. They tell you this, that, whatever. Okay, a story. We all hear them all day long. Everybody's got a story. Some are true, some are not. But this person says they don't have all the rent. That's where you're going to say, well, tell me what you can do. Tell me what you can do. Now, it's a lot of you are like, I don't take partial payments. Well, maybe now you might want to take partial payments. But don't do anything until what? You check with who? The owner. Do not make any mistake where you're going to just go ahead and do something with your tenant, make a deal. Do not make deals without your owner's permission. And I have a form that the owner will sign, they'll agree to the deal. I have seen property managers over the years let tenants slide on things, make a little deal on the security deposit, make a deal on, oh, we'll wait till the 15th when your tax return check comes, or we'll wait, we'll work with you. I've seen the property managers do that, but the owner didn't know it. The owner didn't know it. The owner didn't grant permission. And guess what? You know what? The payment arrangement didn't work out. Didn't work out. And now you're panicked. I know when you're panicked. That's when you contact me and you say, Harry, I've got to get this person out really fast. And I'm looking and I'm like, I see that they're into the second month. And then you tell me the story about they were supposed to, I told them they were supposed to get their check, or I was waiting for this money that was going to come in and they were going to pay on the 15th. And then I forgot and it slipped through the cracks and they never paid. I bet you've been in that situation before. You cut somebody a break and you got burned. But you didn't just get burned, your owner got burned. And if your owner finds out that it's your fault that you did this deal without their permission, rest assured, that owner can come right back at you, and man, you could get in a lot of trouble. And I have seen owners go after property managers. You may be really lucky. Never had it happen to you. But man, property owners, when they find out you tried to cut a deal and it didn't work out without their permission, they can come after you. And money could be coming out of your pocket. You got to watch out for that. Next issue. What about security deposits and last month's rent? If your tenant came to you, let's say you're holding a security deposit, which hopefully all of you are. Let's say you're holding a last month's rent. Okay, you got all this money. You're holding it. Your tenant just lost their job. They have no money. Your tenant has no income, no money. They tried to file for unemployment and it didn't work. So here we go. You now have a situation where the tenant may ask you, well, can you use my security deposit for rent? Can you use my last month's rent for rent? Have you ever had a tenant do that? Of course you have. Well, let's say your owner is broke right now. Your owner needs the money. Your tenant doesn't have any money. You're holding a security deposit. What should you do? Can you tap into that security deposit? Can you touch that security deposit? Can you touch that last month's rent? It's not the last month. It's for October. The last month's. Can you touch it? The answer is yes. You can. You can touch it. You can use it. You can use it to pay rent that's due right now. As long as what? As long as everybody agrees. And we have the form for that. There's an article I wrote about that years ago. It's using the security deposit or last month's rent for money that's owed right now. It's not recommended under normal situations, but in desperate situations, heck yeah, use it. If it's okay with your owner and your owner, like I said, your owner needs some money, the tenant doesn't have any money, then use it. You just can't do it on your own. You can't just take it on your own. You have to make sure that the owner agrees with it because the owner's not going to be protected now. They're not going to have a security deposit, but many times this happens too. A tenant may say, I'm breaking my lease. I'm breaking my lease, use my security deposit for last month's rent. And normally your answer would be no. But in a situation like this right now, maybe you need to consider it to be, let me check with the owner. So you're going to check with the owner. The owner says, yeah, go for it. And you warn the owner. You tell the owner that it's dangerous and that you don't recommend it, but the owner says, I need the money. Let's do it. So we have the form for that. Another one is cash for keys. Cash for keys. Now, this sounds crazy. To give a tenant money to leave sounds really, really bad. It hurts to even say that. Cash for keys. But sometimes it's the smartest thing you could ever do. I did it myself last year with one of my tenants. My property manager put in a nightmare tenant. This lady slipped right through the cracks. She had a criminal case, an open criminal case against her. She had been evicted before. She trashed the last place that she lived, but she slipped through the cracks. I was not happy about this. And the worst part about it was the property manager is also not just my property manager, but he's also a client and he's a friend. So I'm like, oh. Anybody else would have sued this property manager. I couldn't do it. So what do you think I did? Do you think I filed an eviction? No. I paid her to leave because she already had a lawyer. She had a lawyer because of the criminal case. So I literally paid her to leave. I gave her a security deposit back and I gave her a month that less. I said, you could stay this month, do not pay rent this month, and you're going to get, and as you leave it clean, the property manager is going to be there with a check in his hand the day you leave. Could you believe that? Me? I have filed so many evictions. I've evicted entire cities of people practically. And here I paid somebody to leave. And guess what? It's the right thing to do sometimes. Don't pay. You want to pay a lawyer money? What's smarter? Getting somebody out fast and paying them $1,000 or paying a lawyer money and then having it drag out for 2-3 months? Sometimes it's the right thing to do. Of course, who has to make that decision? Your owners. Okay, now, late fees. Remove late fees from your thinking. You're not going to put any notices when June 3rd comes and you're going to serve notices. You're not going to put late fees on anything. If you have a covered property, the law actually says no late charges at all can be charged to a tenant on a CARES covered property. You're going to use the reminder letter. I talked about that reminder letter. If they haven't paid the rent and they're covered under CARES, or right now where they're covered under the moratorium. See, everybody's under the moratorium right now, but after June 3rd, then we have only the CARES people. But what can you do right now? You're going to use the reminder letter. Remember, out of sight, out of mind. You can't do that. Contact your tenant. The best property managers are the ones that communicate with their tenants the most. They don't sit back and wait. They don't sit back. They don't rest on their laurels. People, if they don't get some sort of a bill or a statement or something, people don't pay it. When I moved in, I always tell the story. When I bought my first house in Florida, I moved into this house, and about 3 or 4 months after I moved in, I went to take a shower in the morning. I turned the shower on. There was no water. I'm like, this is strange. So I talked to my wife. I said, Chris, did we like forget to pay a bill or something? There's no water. And she goes, water bill? I never got a water bill. We lived there for 4 months or maybe even longer. I can't remember. It was a long time. We never got a water bill. Why? Well, I bought the house. I never put it in my name. And the water company wasn't very aggressive. So I guess it was in the owner's name or it was in nobody's name. I have no idea. But out of sight, out of mind, there you go. That's what happens. But you can't do that. You're going to communicate. You're going to try to, don't make promises with your tenant though. See what your tenant can do. Have them make the offer to you. And we have all these different payment plans we're going to give you in that Dropbox file. That folder, all different payment arrangements. So you'll see it. You'll see all the different options that you have. Ask the owner what they could do. Ask the tenant what they could do. Check with the owner. See if the owner wants to agree to it, and then write it up. Don't be doing verbal agreements. Don't grab a form that you think that will work. Use the proper form. We got them for you, and they're all free. So you need to prepare for, right now you're going to be preparing for June 3rd. You're going to be working on finding out whether the property is covered under CARES. You're going to do that all right now. This is your job to do. This is serious stuff. You're going to do it. Now, hopefully you're not confused about all this. Just sit back, look at it. Like I said, watch the videos, look at those dates, and try to comprehend it. If you are indeed on a covered property, just be careful, because that is federal law. Very, very serious. Do many of you do self-showings? Do you know years ago, remember when self-showings came out, Rentley, Tenant Turner, Show Mojo? When those things first came out, I was really freaked out about that. I'm like, oh, this is not a good idea. This is going to be very dangerous. This is going to be bad. You know something? I was dead wrong. Property managers are using self-showings now, and that's one way. That's the property managers are doing self-showings right now. All that software that they use for assisted showing stuff, you're not doing a thing. A lot of those property managers are very glad that they're doing that right now, because now they don't have to come out. They don't have to meet with the prospect. They don't have to have that contact, because a lot of people don't want that. From this point on, keep digging deep. Find out. If you don't understand what I said today, you're going to dig deeper and learn this law. Now, there's one final thing that I want to talk about. And this is big. This is something that maybe you're only going to hear from me unless you really watch the news carefully. Over the next weeks, months, whatever, we're going to see something good happen with regards to money. The government, and they're already starting right now, the government is starting to release money to states and local and city, county governments and organizations for rent relief. Now, this doesn't mean that the tenant's going to go there and they're going to give the tenant money to pay rent. No. You are going to be able to give a form to the tenant, or you tell the tenant, this is what you're going to do. You're going to tell your tenant, go here, go there, go here, go there, and have your tenant fill out those forms and get that money. Millions and millions of dollars, collectively billions, are going to be released, and already millions have been released. But if you don't know about it, this is what's going to happen. Your tenant won't know about it. You won't know about it. When you finally find out about it, it'll be 2 months late. And guess what? There won't be any money left. These organizations, this money, you know, with the government, it's not an unending amount of money. They, just like with the PPP loans, they put out whatever, $300 billion or whatever the heck it was, and it was gone, right? The same thing is happening with this rent money. They're pouring rent money. The state is, federal government, they're pouring it on the cities, the counties, and these organizations. You need to find that money. Another homework item. So you're going to study the stuff. You're going to read up and understand it, but you're going to go look for the money, because this money's out there. And when that money runs out, it might not be replenished. So what you want to do is do the homework to find out where it is, so that you could tell the tenant, go here, go there, check with this. Now so after this call today, there's our Zoom call today, get on the phone and start researching. Find out where money might be going. Maybe even call up legal aid. Call up legal aid and say, hey, I'm trying to help out my tenants. Do you guys have a list of places where they may be able to get money? And legal aid may say, absolutely, we do have a list. See how this is going to help you? If you don't do this, the money's going to be gone. It'll disappear. And then you're going to be sorry. This is something that I can't help you with. There's over 500 and something municipalities, cities, counties in Florida. That's an awful lot. And out of that 500 and something, money is going to flow. And you need to find out where that is, because your tenant doesn't have the rent money, but yet it's out there. If your tenant doesn't get it, somebody else is going to get it. Another tenant's going to get it. So keep that in mind and think about that. If you have any questions about anything that we talked about today, if you have any questions you want to put in the chat box or the question box, whatever, I'll be happy to answer your questions. But anytime you have any questions, feel free to email us. You're not going to get a bill. I've been doing this for over 30 years. Nobody has ever gotten a bill for emailing me and for me answering a question. We do it all day long. We make our money with leases, preparing leases. We make our money doing evictions. Everything else is free. The notices are free. Everything is free. And if you don't take advantage of it, then shame on you. When you got a lawyer saying it's free and you don't call up or email that lawyer with a question, you're hurting yourself. This is new. This stuff is new. This is new. You're not used to this. Just like, do you remember the first time you had a tenant die in a house, or a tenant got shot in one of your houses, or the first time you had a fire, when you had a fire in a house? Did you know what to do? You didn't know what to do. You thought you might have known what to do, or maybe you did something and it turned out to be wrong. Think about this as this is all new. Since it's new, relax. Say, I don't know. You know, sometimes I got to tell my clients, sometimes they'll ask me a question. They'll say, Harry, you're going to ask me this legal question. I'm like, I don't know. I don't know. No, I could make up a story. I could try to, like, you know, have lawyers. You ever ask, lawyers hate to say that. They hate saying, I don't know. Some lawyers, oh, well, you know, maybe you could do this, maybe you could do that, blah, blah, blah. Look, tell the truth. You don't know. And don't be charging your client money to find out either. Sometimes a lot of people don't realize that. They go to a lawyer and the lawyer is learning on your money. The best thing you do is say, I don't know what to do here. I'm going to research it. So think about the stop sign. Anything that happens from this point on, you're going to think about a stop sign coming up. You screech on the brakes and you're going to say, this is new. I don't know what kind of notice I could serve. I got a non-compliance. I got non-payment of rent. I got a CARES property, CARES covered property. I got a not CARES covered. I'm confused. Harry goes kind of fast. I don't understand it. And you're going to find out. It's that simple. The stuff is out there. One last thing, a question that I get is, people are asking me right now, they're saying, if we have a tenant who lives in a house and that tenant, we know for a fact they had COVID-19, and maybe they had COVID-19, maybe they went to the hospital, maybe they died, maybe they left, they just left. So you know for a fact that somebody in that house had COVID-19. Are you under any legal obligation to disclose that? The answer is no. You're under no legal obligation. And there's companies that are popping up right now. You know, the companies that handle biohazard, mold, and all that stuff, they're great companies. And a lot of them are members of the Association of Realtors. They're your affiliates. You could trust them. They're coming up with these products, services, whatever, to disinfect and to sanitize. People are asking me, is this necessary? My answer is, I don't know. I honestly don't know. But you'll have to make those decisions, and depending upon the cost, depending upon your risk, whatever you feel like doing. But as far as the law goes, there's no requirement to do that. In fact, many people say that after X number of days, whatever virus, germs, whatever, they're gone. I don't know. That's where we're going to have to continue to find out. This stuff is new to me just as much as it's new to you. I never experienced anything this whacked out in my entire life, and neither have you. This is unreal. The last 50 days or so have been unbelievable because it's just such a mess. So there we are. That's pretty much it. Stick together as a group. You guys you got your property management group. If you need speakers, I know people all over. I know people all over the country, all over the state. And now, you know, Zoom, I never did Zoom until just a few weeks ago. Never. I mean, occasionally I'd attend a Zoom meeting. But, you know, a lot of these different property management groups around the state, they're starting to ask their members, and they're asking their members, hey, you know, would you be interested if we could get good speakers from other states or other parts of the states, people that we couldn't really afford to have? Because some speakers charge money. I'm a free speaker, but I can't do it. I can't be everywhere. There's great speakers all around that your property management committee can get. And for them to sit in a chair in their office and give you a class, it might cost next to nothing. Fair housing speakers, all kinds of people that talk about software, credit checking, pet screening. Do any of you know about petscreening.com? Look that one up, petscreening.com. It solves all the ESA problems and the service animal problems that you guys deal with. And I bet some of you don't even know, but the law, either it was just passed or it's going to be passed. We're going to have legislation this year that's going to help with service animals and fake ESAs and fake service animals. This is stuff that that FAR, FAA, NARPM, this is what these associations are doing. Be a part of what's going on out there. And I'm really happy you guys have a property management committee, but make the best of it. Don't struggle. I have seen more small property management committees struggle than you could possibly imagine. They start up, they have a few people, they get excited, they do a couple events, and then what happens? They fizzle out, right? You know what I'm talking about. Don't let it happen. This is about your business. The more you know, the more educated you are, the more you know about software, systems, programs, marketing, business development. The more you know, the more money you're going to make, the better property manager you're going to be. And final item, right now, this is a time when a lot of property managers, the small ones, there's a lot of people out there. You know, I have over 11,000 clients, but the majority of them, they have 5, 10, 15 properties. I have about 500 clients that have a lot of properties, 500 to 1,000, some more. But there's a load of property managers out there that are managing 5, 10, 15 properties. Think about it. How do you think they feel right now? They're completely lost. So why don't you see about approaching them and seeing about buying accounts? Some of the property managers I know in the state right now, they're buying up accounts. They're growing like mad right now. They decided that they were going to take advantage of this situation and they were going to try to buy accounts and build their business and let the word out that they're here. People pay big money for these accounts. You would be surprised. When I started seeing the money, I was absolutely surprised. I'm like, whoa, I didn't realize that these accounts were worth that much. People are desperate for Florida accounts. There's people out of the state of Florida that are looking to start in Florida. If you are selling your accounts, feel free to email me and I let the word out for free. I'm not a broker. I don't get a dime for it. But there are people who want accounts. And if you want accounts, start letting the word out, because this is the time when the small property manager, the tiny accidental property manager, the property manager that shouldn't be a property manager, there's some of them out there, you know that. This is the time where they need help the most, and maybe they need to get rid of those accounts. So this could be a great time for growth. Do we have any questions? Any questions come in?
Yeah, we do. And thank you. First off, thank you for that. We do have a few questions here. First one is, if you have a form for the tenant, do you have a form for when a tenant passes away or who has access to get the belongings?
Oh, guess what? Great question. Shoot me an email. I'll send you the article. I have a video on I have a video on owner death, and I got a video ready to shoot on tenant death. But guess what? You can't. That's really not about our topic today, so I don't want to talk about it. But you shoot me an email today at harry@ebec.com. I will send you the letter, and I will show you that that's actually impossible to do. When somebody dies, you got a totally different procedure.
Okay. And speaking of sending out letters, you were talking about when you have to make repairs and stuff. Should those letters be certified?
No, you know, people ask me about, I have a video on that too, certified mail. Certified mail is one of the worst possible ways to send anything. It's terrible, because when a tenant gets a certified, what do? They don't pick it up. They're like, oh, I'm not touching that thing. There's only one notice that must be sent by certified mail, right? What is it? The notice of intention to impose a claim on a security deposit. That's the only notice that has to be sent by certified mail. I am so against certified mail, it's not even funny, because tenants don't pick it up. It's the worst. Someday we're going to get the law changed so you could email things like 3-day notices. That's next.
Okay, we know you did cover this quite a bit, but we just have to clarify it. On one of them, can you charge late fees if the property of the owner is free and clear?
Okay, so great. The question is, on a non-covered property, can you charge late fees? The answer is yes, but should you? I recommend that you don't charge any late fees right now. Hold off on your late fees. If you got to, just chill out on the late fees, because they're going to cause judges to knock down cases. You don't want that. Just chill on the late fees. But the answer is actually yes, you can, but it's not recommended. Now, if it's a covered property, the answer is a flat no, and it's right in the law, right in the CARES Act.
If everyone agrees and you use deposit towards rent, can you then collect a new security deposit?
Yeah, I have two forms actually. It's kind of cool. I have one where they just use the security deposit up and that's it. Then I have one where they use it up and they replenish it. Two forms. This is what I'm going to send. I don't know who I should send this to. Should I send it to Kate? I don't know where it should go, but I'm going to send it to you guys, and then you can get it out yourself. It's going to be, you're going to see two forms. One is a flat out use the security deposit and be done with it. The other one is use the security deposit or last month's rent and replenish it. So I got those two forms.
Okay. Yeah, and we'll get that out just so everyone knows. We'll get that out. Myself or Kathy will get that out to everyone. And I think we have just a couple more for you. Can we give negative rental references on tenants from the COVID time period to other landlords that call, especially if they've been late, referring to anything stated in the CARES Act?
There's nothing in the CARES Act that says that you can't tell the truth. If you haven't received the rent and somebody calls you up, you could say, nope, I haven't received the rent from this person in 2 months. There's nothing in the CARES Act that prohibits that. Not yet.
Okay, and hang on just one second. How long do property managers have to wait to report to credit?
You could report immediately if you want, but we recommend that you don't report anything right now. And we expect that there's going to be legislation that's going to probably prohibit you from reporting anything within this whole crazy period that we're in. Because think about it, millions of people are getting their credit trashed right now. Their credit is going down the drain. And you know that there's going to be, they actually tried. In the first version of the CARES Act, there was wording in there that said you couldn't report any negative credit information during this time period, but that never made it into the CARES Act. Will it come back? Oh yeah.
Okay, and just one last thing, this is off topic for today, but do you have something you can send that I can send out for emotional support animals?
I have an article that it's a 2-page article that we give out for free. I just sent one just right before I started this. I sent it to somebody. It explains the ESAs, explains service animals, but you've got a brand new law. I have to check because I think the governor might have signed it. I'm not positive, but there's a brand new law that's going to help out. But I'm telling you, check into petscreening.com. That company's revolutionary. It's been around for, I think, 3 years now. They work for so many people. And this is one of those things, if you're not in the loop, you didn't know about it. If you were in the property management loop, you would have known about this. It's great. The tenant pays for the screening. The tenant does everything. You don't pay a dime. You pay nothing. So they log in, and if it's a service animal or an service animal or an ESA, petscreening.com will actually go through the process to verify that. So it takes you out of that dangerous. That's really dangerous when you're trying to figure out, is this fake? Is this real? You know what I'm talking about. So it's kind of cool. Check it out.
All right, I think that's all the questions that I got that was received. Does anyone else have a question for Harry before? Lynn?
I was just going to say, if no other questions are in there, Harry, we love you. You know that.
Thanks for having me. Thank you.
Maybe we can do a service pet webinar like this again very shortly in the future, because that's a great idea. And the amount of people that showed up on this Zoom call is phenomenal. Yeah. Almost better than I think any class that I've been in for a while. But I think that's it. Yes, this is recorded. Somebody just asked if this was recorded. So the recording will go out. We're going to have access to Harry's notes. Harry, your email address one more time?
Harry@evict.com.
Harry@evict.com.